Restitution and Reparation. English law made the first 19 Africans that arrived in the colony of Virginia indentured servants, not slaves, in 1619. Colonial slave practices in the 13 British American colonies during the mid-1600s were products of colonial government corruption, graft, and racial tyranny. These colonial slave practices in the British American colonies were unlawful, unprecedented, and uniquely an American creation, as they violated the English Magna Carta, 1215, English law, and all royal charters. Furthermore, Parliament enacted the English Bill of Rights, 1689, and Lord Chief Justice John Holt of England's Court of the King's Bench, its highest court, ruled in the case of Smith versus Brown and Cooper, 1702, as soon as a Negro comes to England, he is free. One may be a villain in England, but not a slave, which bound the 13 British American colonies to this controlling English legal precedent. Many have conflated the Atlantic slave trade with British America's hereditary slave practice of partes sequitur ventrum. However, this is a false narrative and untrue. During the transatlantic slave trade between the 16th and 19th centuries, it is estimated that around 12.5 million people were forcibly taken from Africa. Approximately 10.7 million survived the Middle Passage and were enslaved in the Americas. Historians estimate that about 388,000 to 400,000 Africans were directly brought to British North America. But under English law, all such captive Africans brought to the British American colonies could only have the legal status of indentured servants, not slaves under English law, and in fact the British imperial government passed the American Colonies Act, 1766, which legislatively abolished all colonial American slave codes and hereditary slave laws, 10 years before the Declaration of Independence, which made all people of African ancestry living in the 13 British American colonies legally free people by English law and entitled to freedom once America's Congress ratified the Treaty of Paris of 1783. Under England's Magna Carta, slavery on British soil was prohibited by law. Further, America's founding fathers during colonial times were legally bound by an immutable doctrine established by Sir Edward Coke, the Court of Common Pleas in the case of Proclamations, 1611, that declared any pretended legislative act done without proper authority within the British Kingdom was void from the start and could not gain legitimacy over time. Coke's judicial ruling limited the legislative authority of England's king, precluding him from acting beyond his prerogative, and foreclosed the English crown from making new laws or altering existing laws. This 1611 decision applied also to lesser English legislative bodies such as colonial legislatures, and Coke also found that such legislative powers belong exclusively to the British Parliament. Further, the colonial American legislatures were bicameral, with the Crown serving as the upper house and the lower houses being the colonial American assemblies, which did not have the legislative authority to codify any colonial statutes, laws, or ordinances without the Crown's formal approval. The so-called colonial slave codes and their hereditary slave practices enacted in the American colonies were never lawfully sanctioned, as they lacked the required formal approval of the British monarch and Parliament, making them void ab initio, legal nullities. During the English Civil War in the early 1640s, while conflict raged between parliamentarians and royalists in England, colonial American assemblies enacted slave laws without formal approval from England's imperial government. The corruption of the 13 colonial governments in British America and racial tyranny allowed colonial American slavery to exist and become endemic throughout the Atlantic world society. However, legislative acts outside the scope of the legal authority of a British official were invalid and irredeemable, a legal certainty that foreclosed the lawfulness of colonial American slavery enacted by the 13 colonial American assemblies during these times. Furthermore, following England's Civil War, Parliament reasserted its supreme legislative authority throughout the kingdom with the passage of the English Bill of Rights of 1689 and reaffirmed Parliament's exclusive power to legislate on all critical matters throughout the kingdom. Moreover, Parliament also codified and granted fundamental liberty and civil rights for all ethnic Englishmen, including those of African heritage. Slave practices in the 13 American colonies violated the English Bill of Rights of 1689, and all colonial slave codes and their hereditary slave laws were legislatively abolished by the British Imperial Government's American Colonies Act of 1766. For all purposes whatsoever, as these colonial laws denied and questioned Parliament's supreme legislative power over the American colonies and its constitutionally authorized authority throughout the kingdom 10 years before the Declaration of Independence. Yet the institution of slavery in the American colonies persisted, not because Parliament faltered, but because the corrupt hands of colonial governance clung to their exploitation and graft. However, justice was persistent, and it found a resolved voice in the darkest times and a champion in the unlikeliest places. In June 1772, the case of James Somerset versus Charles Stewart reached the highest court in England, and Lord Chief Justice Mansfield delivered a verdict that would echo across the Atlantic and down the ages. He called slavery odious, and that it had no legal basis in the kingdom. Mansfield's words struck at the heart of slavery's moral and legal deficiencies. Slavery could not exist in the kingdom or its territories without a positive law, a deliberate and explicit act of Parliament, and Parliament never passed such a law. In his summary view of the rights of British America, 1774, Thomas Jefferson called the Crown's legislative acts an overreach, writing, "By one act, they have suspended powers of American legislatures, and by another have declared they may legislate for us themselves in all cases whatsoever. These two acts alone form a basis broad enough whereon to erect despotism of unlimited extent." Jefferson railed against what he called the British imperial government's tyrannical disregard for legal authority. Yet he and his fellow slaveholding revolutionaries knew their claim was hollow. 2 years later, Jefferson was assigned the task of writing the first draft of the Declaration of Independence, knowing that the document needed to be cogent, well-conceived, and communicate a compelling message to multiple audiences, including the British government, the colonists, and the broader international community as he began to write. Jefferson structured the Declaration of Independence with the precision of a legal brief, following a classical three-part framework. Argument. The preamble established the philosophical justification for independence, asserting the natural rights of all men and the necessity of dissolving political ties with Britain. Evidence. The list of grievances detailed the colony's case against King George III, portraying his rule as tyrannical and oppressive. Moreover, in the Declaration they accused King George III of tyranny and denounced him for abolishing our most valuable laws and fundamentally altering our form of government. Conclusion. The formal declaration severed all political allegiance, proclaiming the United States a sovereign nation. However, Jefferson knew too well of the attenuated legal problems and abject short-sightedness if the nation failed to break cleanly away from Anglo-Saxon jurisprudence and English law, as English precedents regarding parliamentary sovereignty and rejecting slavery on British soil undermined the so-called evidence section that justified independence. He knew parliamentary sovereignty, the English void ab initio doctrine, and Lord Mansfield's Somerset decision, 1772, that affirmed Parliament's supreme legislative authority throughout the kingdom, negated the Founding Fathers' grievance against King George III and the British imperial government, and exposed the hypocrisy of the Patriots' cause. This reality made Jefferson confident that the United States had to sever itself entirely from Anglo-Saxon jurisprudence and English legal traditions, and he discussed adopting Roman law as a replacement. If English law remained the legal foundation of this new nation, he opined, it would dismantle the very structure of a slave-holding democracy many of the founders sought to preserve. Jefferson's concerns were neither sentimental nor abstract. They were grounded in the stark reality that the British imperial government had abolished the 13 colonies' most valuable laws, a pivotal grievance justifying their claim for independence. Moreover, under established English law and precedent, precisely the doctrine of void abs initio, the legislative supremacy of Parliament, and Sir Edward Coke's 1611 ruling in the case of proclamations, colonial slave codes and hereditary slave laws enacted in the British American colonies were legal nullities from inception. They were never codified as valid law, as they directly violated England's Magna Carta, the governing royal charters of the American colonies, and the English Bill of Rights of 1689. When Parliament passed the American Colonies Act of 1766, it reaffirmed its supreme legislative authority over colonial American lawmaking, effectively nullifying all colonial slave codes and hereditary slave laws, which denied and infringed upon Parliament's exclusive legislative power. Then, in 1772, Lord Chief Justice Mansfield's ruling in the Somerset case made it clear slavery had no legal foundation in the kingdom unless explicitly sanctioned by Parliament, a legislative power it never exercised over slavery in the American colonies. In effect, the Somerset decision rendered colonial slave codes and hereditary slave laws void ab initio and unconstitutional. Jefferson understood the profound implications of these legal precedents. He warned America's Congress that fully embracing English law, along with its long-established rejection of slavery in the kingdom, would destroy the Patriots' cause, undermining both their long-term economic interests and their ideological commitments to the rule of law. Yet despite his warnings, the Founding Fathers and all 13 state legislatures refused to abandon Anglo-Saxon jurisprudence and English law, unwilling to fully commit to the legal preservation of colonial hereditary slavery. However, English law came to underpin their economic and political power, but America's Congress's own legislative actions betrayed them. They deliberately preserved a legal system that blocked any merger of democracy and slavocracy, two irreconcilable ideals that Jefferson had carefully woven into the Declaration of Independence. In doing so, they struck a fatal blow to the moral and legal foundation of hereditary slavery in the United States, yet paradoxically also laid the groundwork for a democratic republic where, under the rule of law, all men could be created equal. In adopting English law, Jefferson forever complained that America's Congress mangled the Declaration of Independence. Wilfred Riley, a right-wing political scientist, fundamentally misrepresents the reality of hereditary slavery in the United States in his book Lies My Liberal Teacher Told Me in Public Discourse. He erroneously claims that generational slavery was not unique, ignoring the unlawful origins of American slavery and the fact that those enslaved were not a foreign people but Englishmen under British rule, entitled to the same rights and due process as any other British subject. Riley's opposition to reparations rests on three flawed premises: that no living American was a slave or slave owner, an argument that conveniently dismisses the legal doctrine of restitution for historical injustices, that wealth does not transfer neatly across generations, ignoring the well-documented effects of intergenerational wealth accumulation and how stolen labor and resources fueled disparities still felt today. That individual success or failure is primarily shaped by personal choices, culture, and policy rather than historical injustice, a facile and willfully ignorant assertion that disregards centuries of legal, economic, and social systems designed to entrench racial inequality. Riley's argument is not just wrong-headed, it is a deliberate distortion of history, crafted to absolve the United States of its foundational crime, while denying the lasting consequences of an institution that shaped the nation's economy, law, and racial caste system. Further, Thomas Jefferson, a slaveholder, founding father, and principal author of America's Declaration of Independence, grappled with the social and moral implications of slavery in his 1785 work notes on the state of Virginia. Jefferson recognized the corrosiveness of slavery, not only on the enslaved but also on the slaveholders and America's populace. He argued that slavery undermined America's democratic ideals and rule of law, warning of its potential to erode the nation's aspirational identity as a just and lawful society. From the outset, Jefferson condemned slavery as a brutal, lawless institution, a form of racial tyranny that stripped black individuals of their humanity and legal rights. His critique went beyond the physical and psychological suffering of the enslaved. He saw slavery as a corrupting force that poisoned the very soul of the Republic, eroding the moral integrity of its citizenry and threatening the foundations of American democracy. Jefferson's assertion that slavery was a form of despotism, a term historically reserved for totalitarian rule, was both provocative and accurate. He knew colonial slavery had no legal standing under English law, and that Parliament had abolished colonial slave codes and hereditary slave laws through the American Colonies Act of 1766, as they challenged Parliament's supreme legislative authority. The Somerset decision in 1772 reinforced this by declaring that slavery had no legal basis in the kingdom unless explicitly sanctioned by Parliament, something it had never done in the American colonies. The Founding Fathers knew this, so they listed the abolition of colonial slave laws as a grievance in the Declaration of Independence. Given these facts, America's claim that slavery was lawfully inherited from England is not just false, it is cynically perverse. Additionally, Jefferson provided a critical lens to reconsider America's narrative that the Declaration of Independence excluded black colonials and that the nation was always meant to be a white republic. He admitted that rebellion was a rational response to slavery, famously warning, "I tremble for my country when I reflect that God is just, that his justice cannot sleep forever, that considering numbers, nature, and natural means only, a revolution of the wheel of fortune, an exchange of situation, is among possible events, that it may become probable by supernatural interference." Jefferson's words foreshadowed the Civil War and the catastrophic consequences of the founding generation's decision to enslave 500,000 black colonials, deny them fundamental due process, and propagate the myth that America was preordained as a white nation where black individuals were mere chattel property. And yet this lie has endured, mutating into the toxic ideology of white supremacy and the gospel of American exceptionalism, twisting the nation's founding ideals into chains of oppression. Jefferson knew the truth. He understood that the enslavement of the 500,000 black colonials mocked the ideals of liberty, equality under the rule of law, and eviscerated justice. He warned that this system, born of greed and perpetuated by willful blindness, was not just a political contradiction. It was a moral catastrophe and a national sin, the criminal origins of slavery in the United States. Slavery in the United States was not an inherited institution. Instead, it was a criminal scheme perpetrated by a government that had been placed on notice, yet willfully disregarded the rule of law. Centrally, in May 1783, British General Guy Carleton made clear to the United States that the 500,000 Afro-Englishmen living in the 13 British American colonies were free British subjects and entitled to be set at liberty under the Treaty of Paris, 1783. Despite this, the U.S. government, fearing political disunity, denied fundamental due process to these 500,000 Englishmen who were legally entitled to a habeas hearing and liberty under the Treaty of Paris. These men, women, and children were not legal slaves under either English or American law, and their enslavement based upon colonial slave codes and Negro laws was baseless. As English subjects protected by an international treaty, they and their descendants are entitled to relief, just as in a wrongful death action against any other criminal entity. Instead, the U.S. government and its officials, acting in their official capacities, sanctioned and profited from this vast criminal scheme, violating both international norms and the very legal principles the nation claimed to uphold. The Book of Negroes, irrefutable legal evidence. A key piece of evidence exposing this injustice is the Book of Negroes, a dual registry compiled in 1783 that documented approximately 3,000 black Englishmen evacuated by the British at the end of the American Revolutionary War. Preserved in London and Washington, D.C., these historical documents are more than a list of names. They are irrefutable exculpatory evidence of a profound legal dispute between two nations, the British Empire and the newly created United States of America. At the core of this conflict was the question of fundamental due process under English law and liberty for 500,000 Afro-Englishmen. The United States claimed that these 3,000 black colonials, and by extension all 500,000 enslaved black individuals in America, were legal property and owned by their American citizens based on colonial slave codes and statutes. However, the U.S. and revisionist historians have ignored Parliament's American Colonies Act of 1766 and the Declaration of Independence, which explicitly acknowledged that King George III had abolished our most valuable laws during British colonial rule, and in direct contradiction to this admission, the U.S. insisted that colonial slave and hereditary laws were still valid when America's Revolution ended in 1783. Britain's rejection of slavery as lawful. Britain, however, held a fundamentally different position. Standing across from General George Washington, General Guy Carleton made it clear the 500,000 black individuals living in the 13 colonies were British subjects, entitled to the same liberty rights as any other white British subject under English law. He pointed to the English Bill of Rights, 1689, and the Somerset ruling of 1772, which held that slavery was not allowed and approved by the law of the kingdom, and had no lawful existence in the British Empire unless expressly sanctioned by Parliament, something that had never happened in the American colonies. Faced with this, Washington attempted to placate Carleton, promising that Congress would resolve the question of liberty for these Afro-Englishmen. But that promise was a lie. Congress did nothing. Instead, the United States ignored fundamental due process and built its economy on the continued enslavement of these 500,000 Englishmen and their children, although being legally entitled to freedom. A calculated decision to defy the rule of law. This was no accident. It was a deliberate, calculated decision. The U.S. government, driven by economic greed and political expediency, defied English law, international norms, and the human rights of those the law had already declared free. The hypocrisy is staggering. Among the central grievances in the Declaration of Independence was the claim that King George III had abolished our most valuable laws, laws the founders claimed were essential to their form of government. Yet just 2 years before the Declaration, Thomas Jefferson had warned that the 1766 American Colonies Act had nullified all colonial laws that challenged British authority, including those that sought to justify slavery. He understood that colonial slave codes were legally void under British law, and that the enslaved were entitled to freedom as British subjects. And yet, the founders made their choice. They rejected these legal truths, built a new nation on an illegal institution, and justified it with a false narrative that slavery had been lawfully inherited from England. Restorative justice for American slavery. Restitution and reparations are distinct legal concepts, and the descendants of enslaved British colonials are entitled to both restitution and reparations. Restitution is a case-specific legal remedy that seeks to restore property, rights, or compensation directly to the injured party, placing them in the position they would have been before the harm occurred. It applies when a specific legal wrong has been committed, such as a wrongful death lawsuit or a court ordering a thief to return stolen property or compensate its rightful owner. In contrast, reparations address broad, systemic, and historical injustices, typically involving compensation from a government or institution for long-term harm inflicted on a group of people. Reparations are meant to redress collective wrongs rather than enforce legally recognized individual claims. In the case of U.S. slavery, restorative justice demands both restitution and reparations. Restitution is a legally justifiable remedy for the direct, quantifiable losses suffered by the descendants of enslaved British colonials, who were denied their rightful liberty and enslaved in violation of the Treaty of Paris, 1783. Reparations, on the other hand, are necessary to remedy the systemic injustices and government-sanctioned policies that perpetuated and concealed slavery's unlawfulness and caused generational racial subjugation. Together, these legal remedies are necessary first steps for restorative justice, which is long overdue. Please share and visit our website at Wells Center on American Exceptionalism and look for future videos.